That's exactly what is the problem.
But there will be
That exactly is.
There is no problem. You don't have to.
You
go
can't
into it.
have not this kind of second bite at the
Seven
cherry.
judges say Basha is wrong. What else?
We
is
can't
left in
deal
the
with
matter?
7 judges.
I think you are more hurt about it than the 7 judges.
Both should be decided together. That's the appropriate.
Not the question. That
remember-
was our case.
If I remember correctly, Madhaj, I had argued,
Don't argue and then.
if you set aside Basha, then
No,
if
there is no setting aside. This is not an appeal.
If you do not agree with Basha, then 81 amendment doesn't arise.
What does 2L do? 2L, or before we go to 2L, what did Basha do? Basha said that AMU was not established by a Muslim minority, but was established under an act of the imperial legislature. Right? And it is administered not by the minority, but is administered by these institutions, by the act. Can by merely an amendment to the definition, can you take away the basis of Basha? Because
My legal
2L does, possibly what the argument, and this we may have to hear the other side in response, because this was not argued in the opening, that 2L merely alters the definition of the expression university. But does the alteration of the definition of the expression university take away the basis of Basha? That the very establishment, now what the 81 amendment does is, it doesn't purport to establish the university at all. Now, it says that the word establish is taken away from the preamble.
but incorporated remains.
Incorporated remain. Then 2L says that it was established by the by the Indian Muslims of India, originating as the MAO College Aligarh,
Correct.
and which was subsequently incorporated.
The argument rejected is in Basha is incorporated by way of a definition.
Now, is this amendment, by the way, in 81, is it retrospective or is it prospective?
Lord,
Lord, our argument before the Allahabad High Court is it's declaratory in nature and therefore retrospective.
Necessarily retrospective.
That was the argument.
Lord, I don't wish to give examples, but if you can change history by changing definition in a statute, your lordships can, with your lordships' wide experience and wisdom, visualize, Lord, what can be done. There are several historical facts, my lord.
No, Parliament can do it.
May, my lord,
But
Parliament think of
Parliament
change.
has the power to do it. Parliament has the power to do it. Because Parliament can, while implementing a statute, subject to a challenge under Article 14, Parliament can...
Competence, yes.
It has the competence to say this
But
is our
whether
view
it
when we enact
amounts
the law.
to effacing
Again,
Basha or not, that's a question.
That the more important substantive point is this really declaratory as they are arguing? Or are you merely amending the definition without taking away the basis of Basha? The latter you cannot do. The former you can do.
You can't sit in appeal. The Parliament cannot sit in appeal and set aside the judgment. It can, if there is some lacuna found by the court, that lacuna can be filled up. But, Lord, it is my submission, and
Basha said that AMU was not established. Basha says AMU was not established by the Muslim minority,
intra-party dispute
but
is
it was
decided.
established under an act of the imperial legislature. Thus, this can merely an amendment to the definition of the expression university take away that basis of Basha.
And, my lord, their argument that it was established by the educational institution of their, by Muslims of India, which originated
Because
at
to take away the basis of Basha, you have to take away the underlying facts on the basis of which Basha has been decided. Have they really altered those underlying facts by this?
I requested your lordships that I would like to read Basha the way I request your lordships to read. Basha doesn't say what they are apprehending. Basha is a sui generis Allahabad, Aligarh University case. And it defines and records certain factual findings also, which, my lord, this amendment of the Parliament seeks to do away with.
Is there an alternate reading not possible? I mean, we are just discussing various options. I mean, we just because the idea, it's not an easy, it's a thorny issue. The original act said the university is established and incorporated under this act. The preamble says established and incorporated. Right? Suppose established was not there. and it had merely used the word and incorporated under this act.
Only incorporated.
In which case, it would have been established by whoever it had been established by, but it was given a statutory form of a juristic personality by the Provisional Act of 1920. Now, Basha relied heavily on the preambulary provision, which says established and incorporate. That is, means you are setting it up for the first time by the Act of Parliament.
Even incorporation would
Is
be
it not
setting
open-
it up for the
right.
first time.
No, that may be a little different because incorporation is giving it a juristic form. Establishment is an establishment, in fact. But is it not? Is it open to Parliament? Is it, or put it the other way? Is it not open to Parliament to say that, well, Basha relied on a statutory provision, namely the word established, to hold that it was established under an act and not by somebody divorced the statute. We will amend the statute to take away the word established, first to make it clear that our intent is that this was only given a juristic form by the Act of Parliament.
Can the
Can Parliament
intention
not do
of
that? Can Parliament not do that?
Lord, can the intention of the Parliament as it existed in 20 be supplemented or amended that this was the intention?
That you
after
can always do. There's no, Parliament's power is untrammeled.
Let that be argued. Lord, they were not comfortable in arguing this point. They said, let it go to the regular bench. I am ready to argue. This is set aside by the division bench of a High Court by a
Parliament does
reasoned
that
order.
all-
I am ready to
Parliament
support.
does that all the time in the case of fiscal enactments. Will have amendments by the galore in the Income Tax Act. The moment a judgment comes, they will amend it with retrospective effect.
My lord, this, my lord, there are, we have, my lord, judgments on.
So what we call a validating statute or
My lord, we have judgments, my lord, whether this can be done or cannot be done, and to support the judgment of the division bench of the High Court, and we have filed an
but
affidavit.
then one thing, let's have conceptual clarity on what we are going to write on. I mean, what is the canvas on which we are going to write? If they are not arguing on the
They are not
validity-
ready to argue.
No,
We
ready to
want
argue.
them to argue.
They are not arguing. That's their choice. One second.
We shouldn't argue the 81 Act.
No, they said that let it go to the regular bench.
Just one
They
second.
say.
One second. We've got our notes. In the opening, they have said that they are not arguing on the validity of the 81 amendment, which forms the subject matter of the Allahabad judgment. So, for the purpose of this reference, then, do we proceed on the basis that the 81 amendment is a valid amendment?
It cannot be.
Oh, sorry,
This-
the 18 or 81, the other way around. Amendment is now effaced from the statute.
Yes, my lord, it's not, it does not exist on
By
the,
this court.
Ah.
Mullahs,
it's not stayed, it's not stayed. The court said status quo because they have granted reservation.
one second.
That was the state, therefore say that the
Where
status quo.
reservation, it is not state, otherwise it's status quo ante.
No, I'll show the
The
order.
order of the court, it's there. It is status quo ante,
No, you are-
other than the issue.
You can't have it both.
If- if-
Let us be very clear.
If I remember correctly, what had transpired was, we were, that in case it's a minority institution, then the corrector will be in terms of the constitution and the rights protected under Article 30. So we're going on that basis.
All,
But to be fair to the solicitor, the argument of which has been raised is that in Badshah, the court found three things. One, it was legally established. Two, in fact, de facto also, it was established not by the state. It was established by the state and not by the minority institution. And third, it is not administered by the minority. These are
And
three.
four, you have whatever rights you had, you have surrendered those rights.
So that is
That's a factual finding.
that's part of the second, that it was not established and administered. It's a part of second and third itself because you surrendered.
So
those.
that factual
So-
finding that you have surrendered,
So your argument is even by adding even by deleting the word established from the statutory enactment, it will not unwind or rewrite the judgment of the
Aziz Basha.
Badshah's case, that it was de facto established by the state.
Mr. One more thing, Mr. Solicitor, I'll have a word with my learned colleagues over the lunch break. I'm just throwing this as an idea. It's not even my confirmed opinion. So it's just for the sake of a debate or dialogue in the court. You will also concede, and the other side will also concede, that the 81 amendment does have some bearing on the minority character of AMU. What bearing it has, it is for your argument, their argument, and we'll decide it. If we accept that the 81 amendment does have a bearing on, some bearing on the minority character of AMU, because let's face it, the object of the 81 amendment was to reaffirm the minority character. That's the whole purpose of 2L and that preambulary change. Now, if the 81 amendment has some bearing on the status of AMU as a minority or otherwise, then can we really decide this without going into the validity of the 81 amendment? Otherwise,
That's precisely we
we may,
requested.
because otherwise we'll be making.
No, that's precisely
Because
we requested.
our-
They were not comfortable.
Because,
They said,
Mr.
go to the regular
Mr.
bench.
Because look at it this way, Mr. Sibal, please look at it this way. We are a bench of 7. Can our judgment be made contingent on what a bench of a lesser constitution will decide on the validity of this amendment? If this, take it against you for a moment, just for the sake of argument. Suppose we reverse the judgment of the Allahabad High Court. And this is only for the purpose of testing the hypothesis.
Yes, yes.
Not at all. Our mind is completely open on the 81. But I'm just putting it against you because suppose we reverse the Allahabad High Court and affirm the validity of the 81 amendment, right? In which case, the consequence of the amendment of 81 is to clearly confer it or recognize it, as they say, the minority status, whether it is declaratory or confirmatory.
Maybe subject to certain arguments
Yes,
which we may
that
make.
arguments are on both sides are open. In which case, how can we say that, well, we will decide this minority status of AMU dehosts the 81 amendment? And the moment you look at the 81 amendment, we have to necessarily look at the Allahabad judgment. So perhaps, I mean, we will all sit down at lunch
But we
maybe for
have
5
been
minutes.
saying that right through.
At lunch, we will all have a confabulation between us because I have not had the benefit of my
Kindly
learning.
not recall, Lord,
colleagues'
it was
views.
our case that your lordship will have to go into the merits. They said, no, this question may be
So,
decided by
if
regular.
Mr. Solicitor, you can continue with the rest of your arguments. But if we come to the conclusion that we will have to decide the validity of the Allahabad judgment here, then you can deal with the validity of that judgment in your
No, Lord,
argument.
first
now.
let them argue. Lord, at that stage, Mr. Dhawan got up and said that I'll
You
take
can
2
argue,
days.
you can support the judgment and we will hear them in response. That will be much faster. Otherwise, then we'll have to again go back to Mr. Sibal to argue.
Let them have, my Lord,
My specific submission in the written submissions is that the 81 amendment is valid. Specifically there.
Obviously,
But
that's
once
the
the lordship said, let it be decided by the other bench, then I didn't complete the argument.
no, my
No, I
Lord.
thought,
Getting away from it.
No, he
Doctor,
said that.
my recollection is that
Not
you
fair.
said, I am not going into that, let it go into the.
Yes, and let it be done by the regular bench. That was Mr. Dhawan's submission.
If I remember correctly.
On our side, we were saying that you will have to decide it.
We are not hesitant. We are not hesitant, but if I remember correctly, I had said, if you,
They have what,
Maras,
on something.
Order is that AMU said we will not implement the 50% reservation. But the status quo, as on the date of the filing of the writ petition, was to be maintained. That is to say, when the petition was filed, Brother Dipankar Datta says 2004, the 81 amendment had already been brought into force. Therefore, the 81 amendment today, as a result of the interim order of our court, is operated.
that's right.
But the question is, my Lord, without going into the validity of that judgment,
Uh-huh.
it would not be possible for your lordships, my Lord, in this.
Prima facie, you may be right on that. Mr. Sibal, just reflect on it at
No, we'll
last.
reflect, but what I said,
Stay of judgment.
1 second.
That's not stay of judgment.
Judgment, my Lord.
Neeraj, look at the latter part. The latter part, that the status quo will be maintained as on the date of the filing of the writ petition.
That is
And
for
if you-
reservation.
That's for reservation, and also, my lords, the next line, since your lordship said should be considered the 81 issue, the next line says it's desirable
After the
that a
other.
larger bench
Then
considers
stay
the
of the
judgment
judgment.
also. Because your lordship put
May-
a
may-
question.
There is no stay of the Allahabad judgment.
Operation of the
per se.
judgment has not
There
been.
is none. There
There's
is
no
no.
stay of the Allahabad judgment.
May I say something, bro? May I say?
What is?
No, may I give a little background?
Yes, it's status quo, Maras, for all other matters.
That is only reservation.
Put the question that should your lordship
Whereas-
get into the 81 issue,
If your lordship,
81 amendment, the same order says that it is desirable that this matter should be considered by a larger bench, and your lordship that today seized of the matter. The same order. In the next
What
case,
has happened,
It's
Madam?
desirable.
What has happened, and I'm going to make this
General
sufficient
importance,
good.
which is there, the matter we.
Maras, I
The matter is referred, not the question. That's the,
I
that was
remember-
our case.
If I remember correctly, Malaj, I had argued,
Don't argue and then.
if you set aside Basha.
No, there is no setting aside. This is not an appeal.
If you do not agree with Basha, then 81 amendment doesn't arise. That's what I had said. If you do not agree with Basha, then the 81 amendment need not be gone into. It's so, if, what my Lord the Chief Justice said is right. If you say that Basha was right, Malaj, then the question of 81 amendment comes in. But if Basha was wrong, 81 amendment need not be discussed.
Vice versa.
If for
What I-
deciding whether it is right or
Allow
wrong,
me, sir, to continue.
81 will have to be examined.
I am not saying no, I'm just, please allow me. So if your lordship's Malaj on our argument says that Basha is wrongly decided, you don't have to go to the 81 amendment. So decide that question, Malaj. What's the problem with that?
Point, Mr. What you are saying, look, Parliament amended the Act in 1981 to really, should we say in a colloquial sense, to override Basha,
That's right.
right? Now, what you are arguing is that if you come to the conclusion that Basha was
Wrongly
wrong,
decided. Yes.
then there was no question.
Yes.
But even so, if we come to the conclusion that that Basha was wrong, we'll have to still, we'll have to still deal with the validity of the 81 Act.
No, but then, Malaj, it goes without saying whether it is trying to override the judgment or not. It is established by the minority, recognized under the.
But suppose the lordship decides that Basha is right, then what?
Don't allow. That question will not arise. Malaj.
What happens then if we decide that Basha is right?
Then it will reside.
If the Basha is right, Malaj, then the 81 issue will have to be gone into.
Only then.
Then by
only.
the regular bench, that's their,
Then only it will.
That is,
Problem is
that's
just
the only issue that is referred to your lordships, Malaj.
Just now you
Whether
said
Basha
that
is right or
1981
wrong.
amendment survived.
Yes?
Problem is that just now you were saying that 1981 amendment is still operative.
If
If
your lordship agree
argument
with
is that
Basha.
it is still operative, then we have to go into
Your
the
lordship
validity of
agrees
that.
with Basha, Malaj. If your lordship agrees with Basha, then of course the 81 amendment is there. If you disagree, yeah. No, don't look at it today, Malaj. Just look at Basha, is it right or wrong? And if your lordship says the Basha is wrong, 81 doesn't matter.
what if the court says Basha is
That
right?
becomes an academic issue. Why? Because it is established by the minority and under 31 Malaj is recognized.
If we say that Basha is wrong,
Yeah.
then according to you, then the amendment in that sense recognizes what we feel also is the correct position.
Then, Malaj,
So what if we come to the conclusion that Basha is right?
then you have to go into the 81 Malaj.
But then if we say that Basha is right, then who goes into the 81 amendment?
Malaj, it is not referred to 7 judges. The 3 judges who would hear it will go into it.
This is the problem.
No, it's not a problem. That's the process.
That's not the.
That's the reference is only que Basha. The reference is not que the 81 amendment. I don't think that we should refer, that we should go into that.
Conveniently, keep having a bite again.
On this at lunch, in deciding, your argument is that if you come to the conclusion that Basha is wrong, then the 81 amendment really becomes redundant. But just reflect on this. Can we decide on whether or not Basha is correct without looking at the statute as a composite whole, including the 81 amendment? Okay, technically today, true, as the solicitor said, 81 amendment is now not on the statute book because it has been set aside by the Allahabad High Court. But everything is live before our court. Now, may not be live before the 7 judges, but it's live before the Supreme Court. Therefore, in deciding whether Basha is right or wrong, Basha itself has interpreted the provisions of the statute while coming to a conclusion, right? It relies on all the provisions of the statute.
That's correct.
Now, can we, while deciding on the correctness of Basha, say that we will look at only some of the provisions of the statute, but we look at the statute minus the 81 amendment? That may be very artificial for us.
I'll tell you, Lordship, the problem that will arise. If I may, I'm sorry. Then your logic, just give me a few minutes, Malas. Either we look at Basha and on the basis of what happened in 1920, that is, look at Basha through the lens of 1920, or we look at Basha in the context of Article 31 when it came into force in 1950 and what happened thereafter. His argument throughout has been, don't look at anything else, look at what happened in 1920. That's been his argument throughout. Please, if you don't want to look at Basha in the context of 20, please then look at this in the context when the Constitution came into force. Then apply all the principles of constitutional law in Article 30 to look at Basha. Then you'll have to do that also. And then 1981. That's not an easy exercise.
Lord Basha also examines 51 and 65th Amendment.
Therefore, you'll have to look at Article 30, sub-Article 1.
And
you don't look at Basha
amendments
on the lens of 1920 then. Then you'll have to do into all that. And my respectful submission is, Mullahs, that exercise need not be done. We are ready to, Mullahs, to argue Basha in 1920. Because that's how it happened. And that's throughout what has been said. Look at the Constitution, look at the regulations, look at what Basha says, look at what the rector said, look at what the chancellors have appointed. This is all Basha 1920. We'll answer that.
Basha on the basis of the position as it stood in 1968.
Yes. Look at it and see whether it was established by a minority or not. It's all you have to look at.
There is one more aspect, Lord.
Let me just
Supposing, my Lord, your Lordship considers 1981 Act also, and your Lordship holds that that Act is valid, it's unnecessary to examine Basha.
You are right, Mr. Deveri, but it's equally valid in case we hold that
I'm
Basha is.
saying consider together, not
So,
for bites.
so the 81 Act, if it is valid, then Basha in any case is overridden then according to us. Because, I mean, that's the argument on.
Even if Basha remains valid, the new Act has come which is valid and therefore.
What they want to do, let me put it bluntly, what they want to do.
Basha relies upon 1951 and 1965
Amendment also, yes.
A part of the 1965 amendment has been done away with the 1981 amendment.
1981.
Unless you go into that whether it was done validly or not.
Impossible to separate this.
Not looking at Basha in the context
That's
of
what we were saying
51
from
or
the beginning.
65.
Truncating.
You're not looking at Basha in the context of 51 or 65.
On one basis. This issue had come up earlier and we discussed, and thereafter we proceeded on this basis. We are examining the validity of the ratio in Badsha.
That's all.
What, number one. Number two, the reason was, why we said so was, we have to see the status of AMU as on the date when Constitution was enforced. In case we come to the conclusion, just one minute, please. In ways in Badsha, when we read, we found there were two aspects dealt with specifically in Badsha, or rather three aspects which were specifically dealt with in Badsha. One is, what is the effect of statutory enactment of a university, of creating a university? Badsha says this is the enactment which establishes the university. This is the only aspect dealt with in 1981 amendment. The second aspect dealt with in Basha. Now we can hold, this bench can hold, yes, the statute established the established the university and therefore AMU came into existence. In which case we uphold that, then 1981 amendment has to be examined. And that can be examined by a separate bench, because then the limited issue is what is the consequence of that amendment. Number one, there the argument which will arise is, could the legislature, by merely deleting the word establishment, override the judgment of this court? That will be the issue, which is a separate issue. We have not addressed, nobody has addressed us. We have already gone through by about 5 days or 4 days. Nobody's addressed us on this.
Would it be
The
separate?
second
No,
aspect,
that's
which
the
was,
question.
the second aspect which is dealt with in Basha relates to administration. And it says it is not administered by the minority right from 1920 or as of in 1950. That's the most important legal issue, because both the sides concede that both the things have to be, in order to be a minority institution, it should be established as well as and administered. So that's the legal issue. The third point raised is, they holds the amendment made in 1981. The Basha holds it's not established, de facto established by the minority, and that issue is again before us. So really speaking, we need not go into 1981 amendment per se to decide whether Basha is rightly decided or wrongly decided.
Mr. Solicitor, Mr. Dwivedi, just 1 second. What we'll suggest is this. You are in the midst of your argument replying to them on merits.
Yes.
You can conclude your argument. Anyway, even if we decide to go into the validity of the Allahabad judgment, you said they should open first. We understand why you're saying that, no difficulty. So on this aspect, you complete your submissions. When we read Basha with you, again, we will be able to then fine-tune our own understanding on whether that issue of the Allahabad judgment should or should not be decided together. We will read Basha with you. So when you are reading Basha with us, or for us, you can also focus on these issues which Mr. Dwivedi, Mr. Kaul and you are saying requires us to also decide the issue of Allahabad in this reference. So right now we can continue with your submission, because you're now on the almost at the latter fag end of your at the end of your submissions.
Certainly, that's not the.
So we'll conclude your
It is
submission.
really this.
It's the appropriateness.
My lord,
Yeah, appropriateness, we
then-
will hear you at the end. Once you have argued on Basha,
Only give me
we
a
will
minute.
hear you for 5 minutes on that, and then we will hear the others anyway, because this has to be dealt with. The merits, everybody will argue. Then on the appropriateness of considering the issue of Allahabad as well, we will hear each of you and then take a call.
I'll just, my lord, add one thing. I'll just add one thing. I bow down.
That's fine.
My lord, what has happened is,
That-
what has happened is this.
As far as the 51 amendment is concerned, Bhasha says it was just in conformity with the constitution. We have argued that the 65 amendment was an emergency amendment, but it was reversed in 81. To that extent, my lord, we can certainly go into it depending on what your
It's not separable. On this argument, it's not
Right.
separable.
Now, you have shown us this. We have anything else that we need to see in the chart, so that then after lunch we can,
The chart, my lord, is,
now,
but my lord, what is
what is
happening?
the remaining part that now
What
you
is
want?
happening is this, what is happening is this, and let me, my lord, be a little more clearer rather than being diplomatic. What they want is, they are taking a chance whether Basha is right or not. If your lordships are satisfied that Basha is right, they will have a second round to say that even if 7 judges said Basha is right, now have a second round that now the basis is taken away and refer this question.
No, if Basha is right, no.
But that may not happen. In case we uphold Basha or agree with the ratio in Basha on the second and third aspect, they may not have any say in it.
My lord,
On the
suppose,
second and
suppose-
third aspect, that is de facto, it was established by.
No,
de facto
I
it
think
was-
what perhaps Solicitor is arguing is that if we come to the conclusion that Basha is right, then the issue of the validity of the 81 amendment will be before a lesser bench, a lesser
Yes,
constitution.
that's
a
what we
three-judge
want, a
bench.
second, Around, my lord.
The argument there
And
could be that, look, the basis of Basha is taken away by the
Therefore, no
1981.
need to go into this. That's all, Mullah. That's all that there will be.
That's exactly what is the problem.
But there will be two
That
bites.
exactly is.
There is no problem. You don't have to
You
go into
can't
it.
have, my lord, this kind of
When
second bite at the
seven
cherry.
judges say Basha is wrong, what else
We
is
can't
left in
deal
the
with
matter?
7-judge bench like this, my lord, that you decide what is comfortable to me and don't
I
decide
think you are
what.
more hurt about it than the 7 judges.
Both should be decided together. That's the appropriate.
Lord, you have,
I think,
the reference is the matters are referred.
On this, we'll just defer it a little bit. You conclude your arguments. We'll also read Basha with you. Once we reread Basha with you, you would have read Basha with two different
I
perspectives.
need to read, my lord, some debates in 65 and that, my lord, that would be very
All
crucial.
right, so now after this, you'll be referring to the debates
Yes,
and then directly take us to Basha, or what's the?
yes, that's the.
And then we'll conclude.
There is only one thing I must.
So I guess about 20 minutes for the debates and about half an hour
I'll
for.
take, my lord, 7 sessions. I'll not repeat any,
No
not
difficulty.
repeat any.
So, but now what remains from your argument is the debates and then followed by Basha.
Basha and, my lord, few other points.
But there is only one thing I must point out, the legal obstacle for them is the court suggested by them. If Lord Basha is to be considered independent, not in the right of 81, virtually these proceedings will be sitting Lord like an appellate proceeding.
That is going to be my submission.
On principle, Lord, larger bench can go into the ratio, not the decision in that case. That's what.
Not the factual findings, my lord, that is going to be my submission.
To convert the reference Lord into an appeal.
This is not an appeal from 5-judge bench to 7-judge bench, intra-court appeal. The argument was, look at this, what he says, look at this, what he says.
In fact, Maharaj, that's going to be one of my
Presently, look,
submissions.
we'll presently be open unless,
There are
until
some
we read
judgments which I'll
Basha.
be citing.
No, until we read Basha with the Solicitor General, let's, because, ultimately a judgment also depends on how it's, how it is interpreted by both the sides. So let's read Basha with you and then we'll take a final call.
And, my lord,
Just
there are
one more
some
anomaly, my
judgments,
lords,
my lord,
to
on
reflect on that, my lord. Just one more anomaly. Assume, my lords, my lords decide that Basha is rightly decided. By relegating the 81 question to a smaller bench, they will get the opportunity to argue that notwithstanding Basha, 81 amendment is declaratory and curative. Therefore, Basha will not apply. Please see the anomaly. Then 7 judges will upheld Basha, and thereafter
have choice of two litigations, my lord, in a matter which are inseparable.
And again, anomalously, my lord, they'll argue what is something contrary to what is decided.
We'll not conclude an opinion at this stage. Let's, because solicitor is on his legs now, and we have almost substantially completed the arguments. One more session is what he requires. So today we'll finish anyway, even by his own.